Hello friends, welcome to iExamB's Law Channel Legal B. In the 300 most important law questions, this is part 9 and we are going to discuss questions on Arbitration and Conciliation Act in this video. Before that, I'd like to tell you about Concept Padhayenge Sabko Sikhayenge campaign. This is a new campaign which iExamB has started in order to clear your concepts. You will find important conceptual videos at our iExamB channel, Target RBI, Legal B YouTube channel, which are all relevant for you. And the first video on Legal B channel was related to types of companies. Tomorrow I'll be discussing about how a company raises capital. So stay tuned, subscribe to our Legal B YouTube channel. Now starting with the first question. Which part of Arbitration and Conciliation Act provides for conciliation? The correct answer is part 3. Second question. When does a conciliation proceeding commence? The correct answer here is when other party accepts in writing invitation to conciliate. This is given under section number 62, commencement of conciliation proceedings. The party initiating conciliation shall send to the other party a written invitation to conciliate under this part, briefly identifying the subject of the dispute. Question number 3. There shall be. How many conciliators should be there? The correct answer is one conciliator unless parties agree to have 2 or 3 conciliators. This is given in section number 63. Question number 4. In a matter for conciliation, if there are 3 conciliators, the correct answer is all of them shall act jointly. This is again given under section number 63 under Arbitration and Conciliation Act. Moving to question 5. As per the provisions of Part 3 of Arbitration and Conciliation Act, conciliation can take place on. The correct answer is disputes arising out of any legal relationship irrespective of its contractual nature. This is given under section number 61. Question number 6. An arbitral award shall. The correct answer is arbitral award shall state the reasons except parties have agreed that no reasons are to be given. This is given under section number 31, forms and contents of arbitral award. Question number 7. If the arbitral award is made within 6 months from the date on which arbitral tribunal enters upon reference, then arbitral tribunal shall receive additional fees. This is given under section 29A, time limit for arbitral award. If the award is made within a period of 6 months from the date of arbitral tribunal enters upon the reference, arbitral tribunal shall be entitled to receive such amount of additional fees as the parties may agree. Question number 8. In an arbitral proceeding, court assistance, the correct answer is can be taken in evidence. This is given under section number 27, court assistance in taking evidence. Question 9. Conciliation involves communication between parties and conciliator which, the correct answer is, has to be kept confidential. This is given under section number 75, confidentiality. Notwithstanding anything contained in any other law for the time being in force, the conciliator and the parties shall keep confidential all matters relating to conciliation proceedings. Confidentiality shall extend also to the settlement agreement except where its disclosure is necessary for purpose of implementation and enforcement. Question 10. What is ADR? The correct answer is alternate dispute resolution. ADR stands for alternate dispute resolution. ADR refers to a variety of processes and techniques designed to help disagreeing parties come to an agreement short of litigation. These processes can be including facilitated settlement negotiation, in which disagreeing parties are encouraged to consult directly with each other prior to some other legal process, to arbitration, which can look like a standard trial. Most commonly used ADR systems are negotiation, mediation, arbitration, etc. Question number 11. Which is the latest amendment passed to Arbitration and Conciliation Act till date? The correct answer is 2021 was the latest amendment, Arbitration Conciliation Amendment Act 2021. This act received parliamentary assent on 10th of March 2021, replacing the Arbitration Conciliation Amendment Ordinance 2020 promulgated by the President of India on 4th November 2020. Question 12. Which of the following is not a qualification of an arbitrator? The correct answer is should acknowledge potential conflicts only. This, as per the 8th schedule of 2019 amendment to Arbitration Conciliation Act, the necessary qualification of an arbitrator were given. An arbitrator should be a person of general reputation of fairness, integrity, and capable of applying objectivity in settlement of disputes. He must be impartial and neutral and avoid entering into any financial business or other relationship that is likely to affect impartiality. An arbitrator should avoid any potential conflicts, and the arbitrator should be capable of suggesting, recommending, or writing a reasoned and enforceable arbitral award in any dispute which comes before him for adjudication. Question number 13. An oral arbitration agreement is deemed to be. The correct answer is it is not recognized as an arbitration agreement. As we know, an arbitration agreement shall be necessarily in writing only. An oral arbitration agreement shall not be considered as a valid arbitration agreement. Question number 14. Which of the following is not true regarding receipt of written communications made under arbitration? The correct answer is the communication is deemed to have been received if sent by judicial authority. This is given under section 3, receipt of written communications, and the communication need not be sent by judicial authority. This section does not apply to written communications in respect of proceedings of any judicial authority. Question number 15. Arbitral tribunal shall include. The correct answer is A and D. There may be a sole arbitrator or any number of arbitrators. Question number 16. United Nations Commission on International Trade Law, that is UNCITRAL, has adopted the dash on international commercial arbitration in 1985. The correct answer is UNCITRAL model law. An act to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards, as also to define the law relating to conciliation and for matters connected therewith or incidental thereto. In the preamble, it is mentioned, whereas the United Nations Commission on International Trade Law has adopted the UNCITRAL model law on international commercial arbitration in 1985, and whereas the General Assembly of United Nations has recommended that all countries give due consideration to the said model law in view of desirability of uniformity of the law of arbitral procedures and specific needs of international commercial arbitration practice. Question 17. As per Part 1 of Arbitration and Conciliation Act, judicial intervention is. The correct answer is permissible only if expressly provided under Part 1. This is given under section number 5, extent of judicial intervention. Question number 18. An exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. The above mentioned statement proves the existence of arbitration agreement. This is given under section number 7, which defines that it is an agreement by the parties to submit to application all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. It includes an exchange of statements of claim or defense in which the existence of the agreement is alleged by one party and not denied by the other. Question number 19. A sum directed to be paid by an arbitral award shall carry an interest. If a sum has been directed to be paid by an arbitral award, it shall carry an interest of 18% per annum from the date of award till date of payment. Question number 20. Last question of this video. Which of the following is a valid ground of challenge to the appointment of an arbitrator? The correct answer is if the arbitrator does not possess necessary qualifications. This is given under section 12 of Arbitration and Conciliation Act. So this was all in this video. In the next video, we'll be discussing questions on Law of Torts and Consumer Protection Act. There is a scholarship test on 19th of November, this Saturday. Attempt that scholarship test and win exciting prizes, and also a chance to win 100% scholarship to our SEBI legal and PFRDA legal courses. If you have any suggestions, you have any queries, you can write them down in the comment below. Subscribe to our Legal Bee channel. This is your one-stop solution for all legal exams. For guidance or direction or any queries, you can also call us on this number. Thank you.